Is it Fernanda Solis Martinez?
Yes, sir.
Ma'am, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On November 19th, 2024, the officer was dispatched to a residence in Harris County, Texas, in response to a family disturbance. Upon arrival, the officer met with the complainant, who stated that he and the defendant, his sister, got into a verbal argument that turned physical. Both parties admitted to striking one another, and the defendant walked over to the complainant's computer and began hitting the computer monitor with a PS5 controller, causing damage. The officer observed the monitor to be shattered, and there was also damage to the headset and controller. The complainant estimates the cost of damage to be $1,120.
Okay, Ms. Solis, I'm going to find that there's probable cause to go forward with the case. How old are you, ma'am?
I'm 22.
Are you here with anyone today?
I'm
Are
sorry.
you here with anyone today? What do you do for a living?
Nurse student in Memorial Herman.
Do you have any kind of income whatsoever?
I would say I make about 1,000 a year, 1,000 a week.
All right, would you like to apply for a court-appointed lawyer, ma'am?
Yes, sir.
Okay, I'm going to have you fill out an application with Stephen. We need to work and we need to figure out what we're going to do, because typically in these types of cases, I bar you from having contact with the complaining witness in this case, meaning that you're not allowed to have contact with your brother.
Yeah.
I don't know, I don't know where you live. I don't know if you live with him. So what I'm going to, don't say anything now. I have a bunch of DAs here. What you say could hurt you. I'll appoint you a lawyer today, but we need to find out the family dynamic, because if you pick up a new case, you start acting a fool in the free world. I'm going to take the free world away from you, and I'm going to put you in jail, and I'm going to make your bond high. And you have to understand that if you don't have anyone that's going to post your bond, you will sit there in jail until this case is over with. And I'm going to tell you, it takes about 9 months just to get a 911 tape, and all that you're working for, all that schooling to become a nurse, where does it go? Right. So we'll figure out that here momentarily. So do not leave until we let you go, though. Okay. Stephen's going to give you the application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box, man. Please.
Yes, I'm here on Mr. I hope I say this right. Barace Kane, 251-5735. Criminal mischief.
Okay.
And I thought we had a deal in place.
So he told us last time that he would have the $1,200 ready to go.
They sent him a bill for 4,000.
Okay. Alex, what's up with that?
So
What's up with that? What's up with
the
that?
bill we have is for $3,900, $1,575.
I have here my notes on 10/1, it was $1,200. I guess it changed.
This is for Mr. Kane. Yes.
Yeah.
The bill we have is stated the amount due is $39,1575. That's the amount due with the
Okay.
bill.
I guess let me speak to the chief and see what, because
Yeah,
I mean, understand it's not with me, it's whatever it was.
I got you.
My notes are all, can be wrong. Hey, I'm sorry to bother you.
No, it's okay.
This is Mr. Kane. In my notes here, I have it beginning of October, the restitution was at $1,200, but I'm guessing or I'm being told it's more now. I don't know what happened.
The bill is $39. Yeah, and there's a receipt too for that.
So Judge, I think initially the confusion with the 1,000 is in the DIMS, the estimation was around $1,000. But when we talked to the complainant, received the invoices and the estimates, it's to the tune of $3,900.
Okay. That's what it is. I mean, it's right. I can't argue with them. They got a bill. That's what they're saying it is. For you to get this case.
On November 19, 2024, a family dispute in Harris County turned physical. The defendant damaged property, striking a computer monitor with a PS5 controller. The court established probable cause, appointed a lawyer, and set conditions: no weapons, no contact with her brother, and careful consideration of restitution and bond options.
Dismissed, that's what the DAs want. They want to make the other person whole. As if it had never happened, the criminal mischief had never happened. To put them in the same place is, what is it? What happened?
3,915.
Right, I understand, but what was it? Was it a car? Was it a computer? An elephant?
The door, Your Honor.
Wow, that's a hell of a door. Made of gold or what?
A mahogany door. So.
I don't know what to tell you, but your other option is to go to trial, you know? Those are the two options that you can pay that money and they end up dismissing the case. You can accept another plea bargain if they have one.
Your Honor, there's no offers on the case right now besides the
You
restitution.
can, if you guys, Mr. Goins, want, you can try to get a different plea bargain. The case is 160 days old, so I will only give you a couple more weeks, but at 180 days, we set cases for trial. So at that time, you need to let us know what you want to do. And if you have not reached a plea bargain agreement with the state, we end up setting your case for trial. I don't know. I don't want you to make a decision now. You guys need to go back and talk and just, you guys decide what you would want to do. And you can always request a different plea bargain if you don't like the one that you have, but they don't have to do anything if they don't want to. It's the state and they reserve the right to, even if they don't want to, they don't have to give you a plea bargain. So I guess you guys step back and let me know what you want to
They
do.
have to prove their case beyond a reasonable doubt.
So, Mr. Goins, before you guys leave today, just
I'll let you know.
just give me a heads up what you guys want to
I
do.
sure will. Thank you.
This way, sir.
So I am putting some conditions on your bond now, Ms. Solis, okay? The two conditions I'm placing on your bond now is that you're not to have, or not to be in possession of any weapons. And I'm also ordering you not to have any threatening, harassing, or abusive contact with a Mr. Martinez, your brother.
Brother, yes.
Okay? I want you to understand what is threatening or harassing. Doesn't matter what you think is threatening or harassing. I could give a rat's behind what you think is threatening or harassing them. It's what he perceives. So if you get into an argument with him and you go, look, is that threatening, harassing? It is. And it can land you back in jail. If you pick up a new case, you violate conditions. No matter how old you are, I don't care. I'm going to put you in jail and I will protect every person in my county. I don't care that it's your brother, it's your mother, father, whoever it may be. Do you understand? Ray, did you want to say anything?
No, Judge, we talked about the no threatening or harassing, and I've explained to her that the state is offering restitution. I just need to get the PTI contract and the restitution receipt so we can get all that paid.
You know, the other thing that you have to understand is that at some point you're going to start working, right? When you start building up a criminal record, employers look at this and they see that it's a potential liability because they may now think, wow, she now has this mischief. Even if it gets dismissed, people can still see it. Man, is she a danger? Is she going to explode on us if she loses her temper? That's what people think. You need to consider this. The older you get, your actions have consequences and it can really impact your future. If you want to become a nurse, this may, form a barrier for you. Consider this when you're out there in the free world. Do you have any questions?
I do. For the no weapons, is that like forever? Like for all my life, I can't have any weapons?
While this case is open.
While this case is open?
While this case is open, you're not to have any weapons whatsoever.
Okay.
We've given you a lawyer. It is your responsibility to stay in touch with Mr. Vasquez. You can see him on the TV there. If he tells me he can't get a hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest. Stay in contact, do what you're supposed to do, and then things will turn out well.
Yes, Your Honor.
All right? We'll have you sign this here now. We'll get you to sign a reset, and then after that, you're on your way. All right? Yes,
Happy
ma'am.
Thanksgiving.
You too.
Judge, we're trying to do a pre-qualifying with you. This is involving Jennifer Gonzalez, okay? I don't know how to be as succinct, but I'll try to be as succinct as I can. The court may recall that she has a PCS that's arising from the same incident that was over there. James Mount and Melissa over the Rick Court and I, we had a powwow yesterday for about 35, 45 minutes to try to decide what's going to happen here. And I'm trying to short circuit things. At the end of it all, we come out this morning. They're going to dismiss the PCS as long as she pleads here. They're allowing her to plead to a time served over here.
I'm not on the second. Sorry,
If you,
not on the second.
that's,
No. If she wants a PTI or if she wants a probation, okay. I think 30 is what we typically do on a second, but not time served.
now the first one was some time ago, Judge, like
I understand.
years ago.
I get it. But,
So,
and she had violations while she's on, right?
well, there weren't violations that couldn't be excused or explained because what happens is she takes Adderall. And so that's what I think the issue was.
No, I'm sorry, not on that second. And it's not just you. It's just, I have before, and people have ran, like literally the week after, they wrapped their car around the pole.
So
And
if I can, and it may or may not impact your decision, you know, she does not have a license, does not drive. Okay, she has that scooter that she's owned that we talked about that's under 8 horsepower, whatever it is.
is it one of those Costco scooters that you cannot take on the street?
Yes, you can't really get on the street with it, Judge. It's not one of those, and she has a license and has not had one. Okay. Now, I know there's going to be a position of a suspension of any license that she may have. I know that will be coming at her. The big issue with the probation, because that's one of the things that we first had talked about. She has to take care, and she's the sole provider for an elderly father. She doesn't drive, is unable to drive him back and forth and everything, but he depends like 100% on her. Now, my concern with the probation, and it was the thing that we kind of tossed about yesterday, is if she
The case's restitution escalated from $1,200 to $3,900. The court explained options: pay restitution for dismissal, accept another plea bargain, or go to trial. Conditions included no weapons and no harassment toward the complainant. Counsel and the court emphasized the consequences of future offenses and the importance of compliance with probation.
she's forced to be in a position to make a decision of doing something for her dad versus appear for a urine test or appear for an office visit or something like that, she's going to defer and say, I'm going to take care of my dad. My dad's life means more than me reporting.
Probation will never interfere with anything that someone has to do for work, caring for another person. They will always work around. So if she gets called in for a drug test, all she has to do is say, hey, I can't come. You know, I can come tomorrow. They're not going to give you grace of a week, right? But it's got to be something reasonable. The next day, perhaps a couple hours down the road, but they're never going to leave you high and dry to where they're going to do anything like that. I can allow, if she does well after the first couple months, I can allow virtual reporting as well, so that she can report via Zoom. You know, if she's doing well, she will still have to, you know, I mean, she's going to have a guardian interlock, right? Because that's what we do on all probations, especially on the second. So
She doesn't have a vehicle, doesn't drive, doesn't have a license.
She'll have a portable.
There's a monitor on her. Can I have her come forward?
Sure.
Come forward, since I don't mind.
she's got a monitor ankle and I'm paying for it now, right?
And it is killing her leg.
We'll take that off. We'll give her a portable device.
That has to be modified because it doesn't look good at all.
Her looks is the least of my concern.
It's painful, Judge, what I'm saying. It's painful.
Hello, Judge.
Hi,
How are you doing today?
I'm doing great. How about you?
Good, sir. Thank you.
What we had discussed, Judge, just so in the interest of full disclosure analysis, we're talking, Marissa had agreed to have a plea to the DWI probation with the terms, including the treatment that's been recommended by the TRAS and all this type of stuff, which we had agreed that would be one of the ways to resolve it. And that would still have them dismiss the PCS. But once we talked about the idea of setting her up for failure, if you would, I wasn't comfortable that she would be able, or this court might even be able to accommodate issues that would arise because she couldn't either get to her meeting or
We
get
can
to
always
the
accommodate.
testing.
Always. There's never a way that we can't. Never doesn't work in our vocabulary. And the thing that I want you to understand is that I don't, you now, once you plead, if you plead to this, it's going to go on your record. It is now a second offense. And the last thing we want is for you to graduate to felony status to where you're looking at 2 to 10 in the penitentiary, right?
Yes, sir.
And I need, and I want to make sure that you understand that there are consequences to behavior. You need to understand that if you ever get in a car, you smell like alcohol, you smell like dope, they're not going to care whether you're spilling, fall down ass drunk, where you've urinated yourself, whether you're vomit. It doesn't take that for them to file a felony charge on you. Even the faintest smell of alcohol, the faintest droopy eyelids, the faintest sway in the wrong way, they're going to charge you with a felony DWI. And now you're looking at up to 10 years in prison. I, at all costs, want to make sure that that doesn't happen. And in my experience, what I've seen when people have too easy, right? It never works out well. And I don't think that a time served on a DWI second is appropriate. I understand that you may take care of other people. I understand that you may have life issues. Actions have consequences.
Absolutely.
You not only have this DWI second, but you also have a felony possession of a controlled substance. He's worked a tremendous deal where they're going to dismiss the felony case. I'm going to tell you now, anytime you can avoid a felony, you're winning. Anytime, it doesn't matter. Because once you get that felony conviction, I cannot tell you how many doors that closes. And not only just from potential work, but I'm talking issues with the state, being able to get state resources, funding for things like food stamps, perhaps lose the right to vote. Just, it really closes a lot of doors. And I want to make sure that that doesn't happen, So,
Judge.
The court stressed long-term consequences. Criminal records affect employment, state benefits, and personal freedom. Probation requires compliance with drug testing, virtual reporting, and avoidance of alcohol or illegal substances. The judge encouraged responsibility, considering family obligations, and emphasized learning from mistakes to avoid future felony charges and severe penalties.
we usually, now this is a second, you, by law, must do 5 days in jail as a condition to probation, right? I don't know if you guys have worked out an agreement where they're going to waive that and plead it down to a first, thereby waiving the jail time, but there's mandatory 5 days in jail as a result of this. That's what you need to understand, which is the other consequence of this. Now, if they're willing to do that, I'm certainly okay with that, but time served. And the probation, if you do well in the beginning and you show us that we can trust you, we will allow you to do virtual reporting through Zoom. But we have to know that you're going to do well. There are not going to be any issues. And most importantly, you're not going to use.
Absolutely.
Because that's what matters.
Yes, sir.
All we're trying to do here is make sure that you don't take a life on the road. So that you have enough of a crappy experience here that 15 years down the road, when you're placed in a position where you're intoxicated out there, man, should I get this car? I had such a miserable time in court with that Judge Fleischer. God, I never want that experience again. That's the idea.
Yes,
because
sir.
I want you to remember me 20 years from now when you're in a position of vulnerability where you make the right decision.
Absolutely. Yes,
And
sir.
hopefully with the probation, we get you understand.
Absolutely, sir. I agree. It's fine.
Now, you have a probation officer, right? Your probation officer is always willing to work with you. If they call you in for a drug test and you're in some kind of situation where you can't, you let them know. We will give you the line to Shatoria here. She's absolutely an angel, is always willing to help you out. We can give you a direct access to her. Or if you have a problem, call us, call me, call her, and we will work something out.
Sure.
But there's never a way that we can't work something out. There's always a way. There's always a way. Always.
Yes, Your Honor.
Okay?
Yes, sir.
Give me a minute or two to
There's no
talk to
rush.
Mike, Judge.
No rush. And I mean, your case, Ms. Knowles, it's only what, like 140 days? Right?
We won't have it over today, Judge.
Or you don't have to.
But I think we're at that point. So I think just a little conversation, I think we should be able to get.
Okay. For sure.
And I appreciate it. Thank you.
Thank you, sir. I appreciate you.
Sure.